Michael Zekome, SAN, Barrister Ifeanyi Chukwuejiofor, in a hot soup. Mazi Nnamdi Kanu, younger brother by name Kanu Ntakanu, have accused them of selling Mazi Nnamdi Kanu to the government of Nigeria. And IPOB have come out and says they have associated themselves from the defamation against Professor Michael Zekome, praises the senior advocate for his previous contributions to the case of Mazi Nnamdi Kanu. Well, the case is on ground now. Mazi Nnamdi Kanu's brothers are accusing Michael Zekome and Ifeanyi Ejiofor of not doing what they're supposed to do as lawyers and representatives of Mazi Nnamdi Kanu that make him to, that make the case to stay till this moment. And that is what, that is the narrative that is going on the internet as I'm talking to you this moment. Mazi Nnamdi Kanu's younger brothers, including other family members, said that this guy sold their brother to the government of Nigeria for a whopping sum of $10.7 million. But before I go on to read the article from IPOB that they put out there at that page, Family Writers Press International, let me first of all read what Mazi Nnamdi Kanu's brother, Kanu Ntakanu, said. Response to Prof. Michael Zekome, senior advocate of Nigeria, and Barrister Ifeanyi Ejiofor, line by line rebuttal. You set out a defensive narrative. I will take it apart, calmly, legally, and precisely, so any neutral reader or judge can see where the paper trial ends and the law practice failures begins. Wahala no dey finish. Okay. Number one, he said, we immediately applied for the certified true copy CTC received on 16th October 2022. Reality check and reply requesting and obtaining a CTC is a weak ministerial necessary step, but it is not an execution step. Lawyers and the public routinely ask for CTCs. The question is not whether you obtain the CTC, it is whether you did with it. Okay, it is what you did with it immediately to compel the compliance with a binding court order. A CTC is evidence of the judgment. It is not a substitute for urgent enforcement proceedings. What should have happened simultaneously on 16th to 17th of October 2022? While waiting for the CTC, you, Michael Zekome, and Ejiofor Ifeanyi should already have been in court seeking immediate enforcement. A, in bracket, an urgent ex parte or inter partes application for the immediate execution of the judgment, and an order requiring the custodial authority to produce the detainee, and or B, a right, habeas corpus or equivalent to compel the production. Merely filing for a CTC and sending letter to the AG and SSS is perfunctory paperwork, not execution. Number two, we promptly wrote letters to the Attorney General and the Director General of the DSS urging compliance. Reality check and reply. Letters to the AG and SSS are worthless, polite, administrative steps. They are not enforcement. State actors ignore letters with impunity. Letters do not coerce. In any case where a person is discharged by court order but remains physically detained, the lawful standard response is to apply to the court or register for immediate execution and to move for committal for contempt against defiant officers, not to rely on correspondence as a substitute for the coercive process. Okay, point of law. If DSS refuses to comply with a court order, the remedy is to return to the court and obtain an order to show case and, if necessary, an order of committal for contempt against responsible officers. That was not shown in any of your paper trial. Number three, following further delay, a fundamental rights suit was filed stamped 21 October of 2022. Reality check and reply. Filing a fundamental rights suit is appropriate in principle, but by itself it is not a substitute for immediate enforcement. The crucial questions are: when exactly was the FR suit presented? That is the Federal Republic. Was an ex parte urgent release order sought in that suit, and was any interim order obtained and served on the custodial authority on an emergency basis? The documents you attach show the FR originating process, but not that an urgent interlocutory order for immediate physical release was obtained and enforced before the government secured a stay of execution in the case of Mazi Nnamdi Kanu. Okay, practical point, according to him, said a fundamental rights suit is law where there is a live binding judgment that has been flouted. A good lawyer must pursue both immediate enforcement in the national courts, showcase and committal habeas corpus, enforcement motions, and parallel fundamental rights litigation. You appear to have prioritized paper filings over immediate coercive process. Number 4, the federal government filed an appeal and an application to stay execution, while filed a counter affidavit. The application was heard and the court delivered a ruling staying execution on the 28th of October 2022. Reality check and reply. Opposing a stay by filing a counter affidavit is procedural opposition, not an aggressive enforcement strategy. The central point is this: if the Court of Appeal has delivered an order discharging and acquitting the Kanu on 13th of October, the immediate focus of any good counsel should have been to enforce the discharge before any stay could bite, not to fight a stay in conventional affidavit battles only after delay had allowed the respondent to obtain a hearing and a stay. This one is what Mazi Nnamdi Kanu's brother said in his write-up. Let me not dwell on this, but we all know exactly what happened. And if I may chip in at this point, I think he might be right in one way and also wrong in another way. Right in the sense that Mike Ozekome and Ifeanyi Ejiofor delayed. The judgment was delivered on 13th of October. Then they have to be going back and forth with paperwork. You are writing paperwork. Well, these people are not writing paperwork. They are going from office to office to file stay of execution. Until 28th of October, you can imagine how many days. 15 good days, they couldn't do anything. They couldn't achieve anything. They couldn't enforce the release of Mazi Nnamdi Kanu. There was an article somebody put out there. I think that one is from one Balarabe, an Hausa man. He said that what happened to the case of Mazi Nnamdi Kanu is from his lead counsels, the people who handled the case within that period of discharge and acquitted, that they didn't do their work well. And also, those visiting Mazi Nnamdi Kanu at the detention facility in DSS are among those who complicated the issue of Mazi Nnamdi Kanu. So everybody have their personal, right to their personal opinion over this matter. Michael Zekome, yes, you secured, discharged and acquitted, but what follows after? That is the question. If anybody call Ifeanyi Ejiofor, they say, no, Ifeanyi Ejiofor, they do, after all, they have secured Mazi Nnamdi Kanu's freedom. Where is the freedom? 3 years after, we are still on the same matter. You drag until all the whole charges were quashed. You got the what they call it. You got the victory, discharged and acquitted, and you couldn't stand your ground. You stay back in your office writing letter, knowing fully well that when letter get to these people, they can even trash it and tell you they didn't receive any letter. Or maybe you are doing big man on the case. I want people now to begin to praise you. Don't they carry shoulder up? Where the person you secured the victory have never been released. I'm not blaming any of them. I know the entity we are dealing with. It is an animal kingdom, a zoo for that matter. So everything goes. Nigeria, or whatever they call them, is a lawless country. They don't have respect for the rule of law. So Let's take it the way it is, or maybe let's take it as a pinch of salt. But let me see what IPOB said concerning this matter, because as I wanna na agaghị ahapụ ike nyere ahụ jeje bụ isi ọkpọ and akwụkwa na dike emeghe ka dike my brother ebufe ya ama nna ya. Let me see what the IPOB they don't say our hand no there for this defamation. Oh, they talk say wetin Mazi Nnamdi Kanu brother they drag say na defamation according to them, but let's see what is right out there, because Mazi Nnamdi Kanu's brother or younger brother have over 27,000 followers on X, and that message he put out there concerning Mike Ozekome and Ifeanyi Ejiofor, he really go viral. Oh, let me see how many thousand views on this matter, because any issue that got to do with Mazi Nnamdi Kanu, one no be small matter. Oh, you will understand that this one, the guy hide his views. Onyoshi, he hide his views. Okay, let us forget about him and then read what IPOB said concerning this matter. The indigenous people of Biafra IPOB movement has denied knowledge, involvement, and further condemning the calumny, that's what they call it, calumny character defamation directed towards the former lead counsel of IPOB leader legal team Professor Mike Ozekome SAN and the current lead counsel of IPOB legal team Barrister Ifeanyi Ejiofor. Currently lead counsel. Okay, no problem. Let me continue. This was contained in a press statement issued by the IPOB Directorate of IPOB Directorate of Saboteurs, Press Secretary Mazi Okadibo Chinwendom on late Tuesday, 12th August of 2025. The statement described the targeted calumny as a impugn on the integrity of the former legal representative of the IPOB leader, and as such required the affirmation of opposition of the IPOB leadership pertaining the false allegations on his person. The statement read, "It has become very imperative for the IPOB Directorate of Sabo DOS to make certain clarification on an important topical issue that is currently going on in the social media. The DOS wish to state without equivocation that the IPOB has absolutely nothing against Barrister Michael Ozekome SAN. On the contrary, we had commended him for being the lead counsel that secured victory for Mazi Nnamdi Kanu at the Nigerian Court of Appeal in Abuja on the 13th day of October 2022. This clarification has become necessary as a result of statements and write-offs circulating online, some of which impugn on the integrity and the professionalism of Barrister Ozekome SAN and emanating from quarters mostly unknown to IPOB leadership and could be misconstrued as being the position of the leadership of indigenous people of Biafra, IPOB. It is important to remember that not long ago, certain siblings of IPOB leader accused the previous legal team headed by aforementioned duo of being accountable for the inability of the current legal team to secure the release of the imprisoned IPOB leader. In their complaints, they stated that the legal team led by Professor Michael Ozekome, who achieved the significant ruling that discharged and acquitted Kanu, that is the IPOB leader, deliberately neglected to implement legal measures to guarantee that the judgment was honored by the federal government and instead traded the IPOB leader's freedom for an honorary title from the federal government. Abi? Professor Michael Ozekome has also refuted these claims by providing documentations related to the judgment and subsequent stay of execution order, which was illegally obtained by the federal government. And you allow it to stay to force stop the unconditional release of IPOB leader. So it was illegally obtained, and you as SAN, who knows the law back and front, and you allow it to stay. You don't say these people, sometimes they think they are making statements, but they are indicting themselves with more. Oh, so the document they used to do stay of execution of the case you won is illegally and you allow it to stay. Okay, in the light of this, the IPOB statement not only backed the claims of the Prof. Michael Zekome, but also revealed how his effort to secure the release of the IPOB leader following the judgment delivery was heavily sabotaged. With the very credible information at the disposal of the DOS, we are aware of the genuine effort expended by Barrister Michael Zekome's SAN and his team of lawyers for the freedom of Mazi Nnamdi Kanu, and how this effort was deliberately and consciously sabotaged. By who? Thus, the US wished to assure the SAN that the IPOB leadership and the generality of Biafrans has nothing but respect for him and his team of lawyers that secured the positive judgment of acquittal at the appellate court for Mazi Nnamdi Kanu, the leader of the indigenous people of Biafra. Finally, the statement urged the general public to ignore false stories emanating from quarters and individuals who has no recognition nor possesses informed knowledge on how the IPOB institutional structure functions. At the risk of sounding repetitive of what is already in the public domain, IPOB is a movement with established structures and institutions. The affairs of the indigenous people of Biafra, IPOB, are managed by these internal structures of institutions of IPOB. Views of writers unknown to the IPOB leadership or even individuals that are identifiable do not represent the position of the IPOB movement. We stand on a high moral ground and truth in this pursuit of our freedom as a people, and it is only on this truth we shall lay the foundation of new sovereign Biafra nation. So, my people, this is the message I brought to us here. Well, I'm not a lawyer and I cannot speak what I don't know. Maybe they might be right or they might be wrong. Maybe Michael Zekome might be right and he might be wrong. But as it stands now, there's no, your right can be somebody's wrong and your wrong can be somebody's right. So let us just keep our arms crossed as we watch all these dramas, the way they keep unfolding. Because we are dealing with a zoo, an animal kingdom, who is begging a terrorist to stop attack people. And they are sending clerics to go and have a meeting with that same terrorist. And then the innocent, who you captured with nothing, not even a razor blade, is now being detained and charged for treasonable felony and terrorism. Anyway, my people, now here we go take back break. In fact, let me know what you think concerning this matter at the comment section of this video. Like, share, and make sure you keep subscribing for more interesting videos. Okay, Messiano.